Okay, so we'll make a start. So this session is then all about how to respond to subject access requests. I'm Rachel Masterton. I'm the Deputy Data Protection Commissioner here at the Office of the Data Protection Authority. And a warm welcome to you all joining us for this session. If you're joining us from outside of the Bailiwick, please note that this covers subject access requests specifically in relation to our local legislation, although that is very similar to the EU's GDPR. But there may be some aspects, particularly when we get to the exemption section, that aren't replicated in the legislation that you need to be following if you are following the GDPR rather than our local legislation. But regardless of that, we hope that the session is useful wherever you're from. And just as well to remember, or so that I remember, to let you know that we have Tim assisting me today with some polls. So as we go through the session, we'll be putting up some polls to seek your ideas and thoughts around some of the questions to do with subject access requests. And to make sure you're all still there, because it's very disconcerting sitting here and not knowing what's going on out there and not having the feedback that I'd get if I was in person. So the polls let me know what's going on. So thank you for that. So the aim of today's session then is we want you to go away with a greater understanding of how to respond to subject access requests. We've used the words greater understanding here. It's impossible to go into any huge detail, but we do want to make sure that you understand what's required when looking at subject access requests, what a subject access request means, in fact, so you can respond effectively when you get those requests in. We're not going to cover all the detailed practicalities around subject access requests. That will be different for each of you. The law sets out a framework in which you need to operate, but much of how you go about responding to a subject access request will depend on the processes and procedures you've got, the data you've got, and how that's structured. But we will cover off what you need to think about when putting together processes. We did a practice run of this session, and so just to prepare you, I've been asked to let you know there's a very detailed section on exemptions, which contains a lot of information towards the middle and end of this session. Please do not try to take extensive notes during this session. They're quite detailed potentially, but we will be, as I say, recording this session, so you can refer back to the recording if you feel you need to go into more detail to refresh your memory about exemptions. And in addition, we've got some quite comprehensive guidance on our website that you can look at should you need to think about exemptions. So if you just focus on what's being said today and then revisit any sections you need to later on, it will give you possibly the best outcome from this session. So what we're going to do today then is do an overview very quickly of data protection. For those of you who have attended sessions previously, this will be a brief recap, but it's so we're all thinking about the same thing. Then we'll look at what the law actually says with regards to subject access requests. And think about who should be responsible when it comes to dealing with requests. Sometimes it's assumed it will be the data protection officer, and it's not always the best place for that function to sit. So we'll think about what you need to do to make sure you respond appropriately and get the right people involved. And then we'll finish up after going through a bit more about subject access with addressing any questions that you've sent us via the chat feature there. And then just to finish off, we'll be inviting you to take your newfound enthusiasm about data protection and subject access requests and share it with others as part of what we're calling Project Bijou. So we'll go into a little bit more detail about that at the end of the session. So first of all, then, what is data protection? Well, locally, as I say, we have our own data protection law, the Data Protection Bailiwick of Guernsey Law 2017, and it follows in the footsteps of the GDPR. It is essentially equivalent to the General Data Protection Regulation that came into force across the European Union on the 25th of May 2018, the glorious 25th of May when our legislation also became active. The data protection legislation is designed to give individuals rights regarding the information that is processed about them and to place obligations on organisations that process that personal data. So make sure that organisations understand how to process data well, to make sure that individuals know what's going on and that they can question those processes. So if you think about it, this will affect you in two contexts. You will be here listening to this representing an organisation. And so you can build that into your processes and procedures there, but also you as an individual have the rights the data protection law provides, including the right of access to your personal data. And so you can use some of the information here to understand how to do that from a personal point of view, if you ever wish to make a subject access request. Data protection legislation is all about personal data, and the definition of personal data within the law is information relating to an identified or identifiable individual. So if you're able to identify somebody, or you are planning on identifying somebody as a result of the information that you hold, then that is personal data. It's important to bear in mind this is not just the factual information you may hold, but also includes any opinion, and that is particularly key when you're thinking about subject access requests. Because individuals can have access to the personal data you process, that will include any opinions that you have recorded about that individual. And I have seen, both in this job and in my past roles, some rather interesting opinion expressed in a way that's perhaps not been helpful in a situation. And it's just a word of note to bear that in mind when recording opinion. It's perfectly okay to record opinion if you are interviewing people for a job and you're recording your interview notes. Then an amount of that will be opinion. But bear in mind, somebody could have access to that, and there are ways of expressing things that go over better than others, and particularly if it's likely somebody will have access to that information. When thinking about personal data, you've also got something called special category data, and that's listed on the right-hand side of the screen. And this is afforded a much higher level of protection. It's based very heavily on the European Convention of Human Rights, and you will process to a greater or lesser extent probably some of this information. If you have staff, if your organisation employs people, then you may well hold information about their sick records, for example, particularly at the moment, with us being often here, there and everywhere, going for PCR tests and the rest of it, because we're unwell, you'll be recording that information. And you need to bear in mind that that is special category data and requires this extra level of protection. But you may have some of the other information here depending on the organisation you are and the role you perform. And so it's just to bear in mind that this is something a little bit different. And because the definitions within the law can only go so far, in reality, these are the sorts of things we're talking about when we're thinking about personal data. So those sorts of things there, what my boss thinks of me, photos or footages of someone, online activity, medical records, of a huge gamut of information is personal data and comes under the remit of the data protection law. And as such, the rights apply to this information. Data protection is all about protecting this type of information. And with somebody, with people at the heart, with humans at the heart of this, it's actually not just data protection. You think about it, it's people protection as well. So we're going to go to our first poll. So Tim, if you are ready, can you launch the first poll for me, please? This is very much like the next slide, please, a bit of the press conferences we've seen from the UK government. So your question here is, have you had to respond to a subject access request in the past? So just to gauge how many of you are going to be assessing past performance on this slide, and how many of you are here prepping for the future. And then using the lessons learned in either context to know how to deal with things going forward. So just another couple of seconds on that poll there. We'll see, are we going to have it at a tie, or are we going to have one more person to tip it one way or the other? There you go, thank you very much. Not as if you're sitting there working out the same answers. If we could end the polling there. But yes, we've got a fairly mixed field out there. Some people have dealt with subject access requests before, so 48% of people have had to respond to a request, and 52% of people have not had to respond to a request. So that poll can then disappear, please, Tim. Lovely. Okay, so what is the right of access? A bit sneaky asking you whether you've had one before we've talked about what a right of access is all about. Put simply, though, a subject access request is when somebody asks organisations about the information that they hold or process about them. So it's about, what do you know about me? And what do you think about me? And what do you think you know about me? Some interesting things can come up in that area. And then what do you do with all that data? So it's not simply just a case of handing over the personal data that you process, but you do have to provide information about what you do with the data. And that information is essentially based on Schedule 3 of the Data Protection Law, will be very similar, in fact, to what you provide as part of your data processing notices or privacy notices. So when somebody makes a subject access request, the right that they are using means that they have the right for confirmation of whether any personal data is processed. So the first off, do you have or are you processing any personal data about me? And processing is a very broad term, as we are aware. So it's pretty much everything you do with personal data. So the collecting, the recording, the use within your organization, the disclosure of that data, or how you store it, all the way through to the destruction of that data at the end of the data lifecycle. That's all processing. So people have the right to be told whether or not there is any personal data being processed. And if you have no personal data about that individual that is being processed, if you as a controller are not responsible for any processing, that's the end of it. No, I don't have, I'm not processing your personal data, and then that's the subject access request gone. But if you are processing the personal data, then you should provide, as I say, this list of information from Schedule 3 of the law. And that is information about who you as the controller are, the identity of your organisation, how they can contact you. It should include contact details for a data protection officer if there is one within your organisation. Thinking back to the slide about personal data, you need to confirm whether you are processing any special category data about the individual and tell them what that is. You need to tell people the source of the information. So are you collecting all the information that is being processed solely from the individual themselves, or are you sourcing that information from elsewhere or creating that information inside your organisation by virtue of the services or goods that you are providing the individual? You need to make sure that you let them know the source of the data. Most importantly, you need to think about and express to them the purpose for which you're processing their personal data. So what are you doing with that personal data you hold, and what legal basis you're relying on for that processing? So which of the conditions from Schedule 2 of the law, the lawful processing conditions, are you relying on for each of the things you're doing with the personal data? Sometimes it will all be wrapped up in one lawful processing condition, contractual perhaps if you're delivering goods or services to the individual. On other occasions it will differ depending on what you're doing, but you should be articulating that. If you're relying on legitimate interest for the processing, then you should be explaining to the individual what your legitimate interests are as an organisation so that they can understand those. The notice you provide individuals should include the recipients of the personal data, so who else might get hold of this information other than your organisation, so that they can understand where it's going. And if you're transferring personal data off island or outside of the European Economic Area, so the European Union plus the EFTA countries, then you need to be explaining the safeguards you're using for that transfer. And that's all outlined within Part 10 of the Data Protection Law. You need to explain the retention that applies to the personal data you process, whether that be the specific duration for which you retain personal data, or whether it's the criteria you use to decide whether to get rid of personal data or to continue to hold it. That all needs to be explained. You need to explain that individuals have data subject rights. Now, they've already exercised one right, but they may not be aware that there are other rights out there that they can use, and this should be covered within the information you provide them. If you're relying on consent, then you should explain that they have the right to withdraw that consent, at which point the processing will cease. You need to also explain that they have the right to complain both to us as the Data Protection Authority, or to the courts if they feel that their personal data has not been processed appropriately. And finally, if you're doing any automated decision making, computer says no type processing, you need to explain to them what that looks like as well. And then on to the bit that everybody does remember, which is the copy of the personal data. So individuals are entitled to a copy of the personal data in writing unless they've agreed to receive it in another format. And frequently, if somebody has made a request by email, then responding by email is sufficient. But if you're unclear, then you can clarify that with the individual. And there is no longer a cost around subject access requests. So for the first copy of personal data, it must be provided free of charge. There should be no cost to provide that first set of personal data. If for some reason somebody wants another set, perhaps they don't themselves have access to a photocopier to copy that information and would like you to provide them with an additional set that they can use for something, whatever that might be, then you can charge a reasonable fee for the administration of that request in order to provide that second set or more sets, depending on what you've been asked for. But that first copy of personal data should be provided free of charge. So thinking about data protection legislation and about the role of the ODPA, we'll have another quick poll here. So if Tim, you can launch this next poll, thank you. What percentage then of the ODPA's publicised enforcement action in 2021 was due to a controller not dealing with subject access requests properly? So what do we think? Is it all, is all we do deal with subject access request related complaints? Or are we dealing with a lesser percentage than that? So if you want to have a go, and this might be a bit of guesswork, it might be a bit of trying to remember what we've publicised in the last year. But yes, we want to have a couple of minutes just trying to work out how many people have responded to that. Okay. Right, I think if we shut that poll there, lovely, thank you. So on then about 20, this is going to be a lot of percentages, people, so hold up, bear with me. So 36% of you think that we have done about 20% of our cases have been, publicised cases have been around subject access requests. We've got one person that thinks it's less than 10%. And 2 people, 9% of people think that it's up as high as 80%. Well, I have the results right here, and the 23% of you that said 60% are in fact correct. So in 2021, 60% of our cases, 3 out of the 5 published enforcement actions have been have dealt with subject access requests. So complaints that somebody hasn't dealt with the subject access request properly. This is taken from the public statements that we have on our website for this year. But anecdotally, we do get an awful lot of queries around subject access. We realise this is one of the more tricky areas for organisations to deal with. And so we get queries from both organisations, from controllers and from individuals about how to deal with a subject access request, what it means for the individual and what it means for the organisation. That's why we're doing a specific event on this area. So the law requires that in relation to data subject rights, and there are a number within the legislation, we're only focusing on one today, but the law requires that a controller must take reasonable steps to facilitate the exercise of data subject rights, and they must be able to demonstrate that compliance. So it's not simply enough to get a request in and to deal with it. You need to be able to show that you're dealing with it appropriately, and you need to assist and provide, as I said, those reasonable steps to facilitate the exercise of data subject rights. It shouldn't be just, oh, here we go again, this is a burden, let's try and get this out as quick as possible and not really do it properly. It should be something that is, you put the person at the heart of the process and assist them in taking, as I say, these reasonable steps to facilitate their data subject rights. So if we're thinking about what to do to get ready to respond to a subject access request, well, you don't necessarily have a great amount of time. So I'm encouraged by those people at the beginning when we asked the question about have you dealt with one already? Nearly half of you haven't had a subject access request yet. I'm obviously here to find out what's going on before you have to tackle this process yourself. Because as I say, there's not a great deal of time if you just wait for one to turn up and then think, what do I do with this now I've got it? So take some time before you get your first request to think about the process, what that means in your organisation, and document that process so it's clear how this is going to be handled. A key point when thinking about responding to or getting ready to respond to a subject access request is to know your data. So where is your data? Where's it stored? Is it hard copy? Is it electronic? Do you have the same information in both places? Do you have different information in those places? Which systems are they in? and make sure that you understand how your data hangs together. So doing some sort of data audit or data mapping exercise can be really helpful for subject access requests, but generally for compliance with data protection, knowing what you've got is key to a lot of those compliance and accountability activities that you need to do. And a question we've had in the past, or a comment that's been made, is it's really difficult to respond to subject access requests because the data is all over the place. And do I really have to try and pull that all together? And our response is frequently, well, yes, you do need to give it a shot. And also going through this process and understanding where your data is and how it hangs together can be good just generally for business purposes. If your data and systems are so complex and convoluted, you can't find somebody's information when they make a request, you're likely not leveraging the opportunities you could out of that data. It's an important resource. It costs you money to have it. If you've got your system structured in such a way that you can lay your hands on it and use it to the best, both for subject access data protection processes, but also for business purposes, then you're really getting the best out of this asset that you hold. And I mentioned at the beginning about understanding who's responsible for this process, and it's an organisational process. So the controller is responsible for complying with a data subject access request. And it's not necessarily just the data protection officer that you want to have involved in that process. Not all organisations are required to have a data protection officer anyway, so leaving it to them will mean half of the organisations don't have someone to do it. But sometimes it'll be, in a larger organisation, better to get people in from each of the business areas so that they can understand and get involved in the process and explain how they process personal data, how they'd get that data back, what that means to the organisation. And when we look at exemptions in a few slides' time, it may not be the data protection officer or the person that's collated that information that is always the right person to make the judgment about whether an exemption fits or not. It may be that actually somebody in compliance is much better placed to say, for that information, whatever it might be, yes, there's an exemption that could apply and it would prejudice to disclose that, so we need to hold some of that back. And it's not reasonable in a large organisation to expect one person to know all the answers all the time. Thinking about the data you hold, minimising your personal data can be very useful for this process, because if you don't have it, you can't provide it. But also more generally for data protection compliance, personal data is a risk. If you hold personal data, then there's a risk that it's going to leak out your organisation. So the less you hold, the better. It costs money to hold personal data, whether it's in electronic or manual storage. So if you minimise your data, make sure it's nice and streamlined and your systems and processes are agile. When it comes to a subject access request, you may not have as much to need to provide. And again, you may be using data better and not spending lots of time and money protecting data that actually you no longer need. We stress that you should test the process, so to make sure that you can find the information, that you can run through the process so you understand what it all means. And think about the link between data protection and customer service. Organisations that embrace data protection, assist people to exercise their rights and treat people, put them at the heart of the organisation, whatever that organisation might be doing, build up trust and confidence, and getting that link to customer service rights is brilliant. Not thinking about subject access requests as being a burden, as being, oh, look, it's something I'm going to have to do for this annoying person, but think of it as, right, this is our opportunity to show what we do and to make the customer experience, if it's a customer that's made the request, a better experience. Then document your decision making. So document both the process and why you've reached the decisions you've reached when it comes to involving whoever you involve. And make sure that as you're going through the process, as you're responding to a request, that you're documenting the decision making that you do then. Whilst you can have a process in place, subject access requests will involve a certain amount of case-by-case assessment. And where you do that, you need to document why you've made the decisions you've made. And test the process again. So we've put it on the slide twice. It's not an error. Give it a shot, give it another go. So test the process, see how it goes, make some amendments and test it again. And be ready to recognise a request and deal with it. And recognising a request is a key part of this. Not everybody that makes a subject access request will say that they are making a request under section 14 of our law. 14, 15, there you go. Anybody that picked that up. So yes, not everyone will reference section 15 of the law when they make their request. Not everybody will use the words, I want to make a data subject access request. They may just say, I want all the information you've got about me. And that should still be viewed as a subject access request and run through the process. So make sure that the people that are dealing with the correspondence, the frontline people opening the letters, reading the emails, understand what a subject access request looks like and start to put it through the process, because it's not good enough 2 weeks, 3 weeks after you've got it to realise that you should have been handling it as a subject access request rather than however else you were dealing with it. The clock starts ticking once the day after the request has been made. So the day after you receive the request, that's when you need to start the clock ticking, as I say, and that's regardless of whether you've realised it's a subject access request or not by that stage. So how to respond to that? Well, you've done all your preparation, so you can sit back and relax and know you're ready if a request comes in. So that request comes in, and what do you do now? Your process will kick in. We would suggest you acknowledge the request. Make sure that you let the person know who's made the request that you've got it and that you're dealing with it. Frequently, we will get calls from people who say, I've made a request and I've heard nothing since. And it may not be that the timescales are up yet, and we'll talk about timescales in a moment, but they just don't know whether or not anybody's got it and whether or not anybody's dealing with it. So going back, just to let them know and to establish with them that you realise the date by which it needs to be responded to is whatever it is, shows the individual that you're taking it seriously and you're working with that. It's also your opportunity to see if there's something specific that they might be asking for. So whilst a subject access request is purpose blind and somebody doesn't have to say what it is they're going to do with the personal data once they've got it, you might want to go back and say, to assist us or to make sure we don't miss anything, is there something particular you were after? So that you can understand a little bit more about what they're expecting to get back as a result of this. Once you've done that, it's starting to gather the personal data about the person. So getting your data mapping or your data audit out, your process that you put in place to understand which systems you need to go to. So if it's a staff member or former staff member making a request, it's this set of systems relating to HR. If it's one of your clients, then it's probably a different set of systems. And it's making sure that you then gather that information about the person. And then getting the right people in the room to assess and review the personal data that's gathered. As I say, expecting the data protection officer or the person that's responsible for coordinating this process, expecting them to know the intricacies of all areas of the business and which exemptions apply at all times, maybe expecting too much from one person, and to get the right people in the room to be able to do that for you or with you, rather than relying on one person to do that. And then you've got the response to the individual. So confirm you're processing their personal data, provide a copy of the information that you've got, and provide a copy of the Schedule 3 information explaining how you use that personal data in a safe and secure manner and in the way that they wish to receive it. And if only it were that straightforward, we wouldn't have 60% of our publicised enforcement actions being around subject access requests. But of course, nothing is quite as straightforward as 4 steps. So we'll now look at things like timescales and other areas that you may need to think about when you're responding to a request. So the first thing then, this idea about timescales. So under the legislation, you are required, as soon as is practicable, that wonderful phrase that doesn't appear anywhere except in legislation, and certainly within 1 calendar month, to either respond in full with absolutely everything, or if you're not going to respond to a part of the request, notify the requester, get back to them with what you've got and why you're not going to respond, and make sure that you've included the right to complain. Or if it's a complex request, and this is the request is complex, not your systems are complex. If the request is complex, you can extend the response time by a further 2 calendar months, but you must notify the requester and provide the reasons for the delay in the 1st calendar month. And as I say, my DPO is on holiday, not a great reason for not being able to respond within that 1 calendar month. Or our systems are so complex and out of control, we have no idea where anything is also not a great reason for extending by those 2 further months. But if it's the request that's complex, so if they've asked for some very intricate information, if they've asked for some information that's bound up with lots of other people's information, and it's therefore going to take you a lot longer to go through it to make sure you respond appropriately, then you can seek to use that additional 2 months. And if an individual is unhappy about you seeking those 2 months, they have got the ability to make a complaint to this office about the fact that you're not responding within that first calendar month. So keep the individual involved so that they know what's going on, what they can expect from you. And document your reasoning for any decisions you make out of the ordinary. So if you are extending, make sure you document that. It is for you to demonstrate as the controller that the request is complex and you need the 2 months, extra months, not for the individual to demonstrate the request isn't complex. So make sure that you document your decision making and your reasoning. Now, sometimes it may be that you need to establish the requester's identity. It might be somebody you don't do business with a lot. It might be somebody you think they've moved recently. Whatever it may be, if you need to establish the identity of the requester, then you can do that. But the check must be reasonable. So it must be something that's appropriate for the nature of the request you're making. So if you are a company that only ever deals with somebody online, and you deal with them at one specific email address, and you've never had cause to have a look at their photo or their passport in the past, asking for a passport may not be sufficient to establish the requester's identity. It might not meet the requirements you need, and it might be excessive data. You're asking for something you don't need, something you've got no means of checking is right. I might be making a request on behalf of somebody else and have managed to get a copy of their passport. That doesn't prove I'm who that person is. So if you're unsure about the identity of somebody, seek some information that only they would know so that you can understand if it's the right person. So it may be more appropriate if a request comes in from a different email address to the one you normally do business on, that you say, please, can you make this request from the original email address? You send an email to that original email address and say, we've had this request, is this really you? And if they come back and go, yes, it was, for some reason, I just made it from my iCloud email address instead of my CWGSY request, then you can establish it's the right person and go ahead with the request. So just make sure that you're asking for something that's appropriate when you're asking for request to establish requester's identity. And be aware that whilst the clock doesn't start ticking until you've got all the information you need, so going back and saying, is this really you? Can you prove to me it's you before I do all this? The clock doesn't start ticking until the person has done that, but it's not an excuse to sit on the request for 8 months and not do anything with it, because at some point you're going to get around to telling the individual that you need some more information before you can process that request. So make sure that you do this in a timely fashion. As I say, until you get that confirmation you need, the clock stops ticking. The 1 calendar month doesn't tick away until you've got all that information. Now, there may be occasions where you get a request and it's what's known as manifestly unfounded, which is a lovely legal term which sounds absolutely horrific, but essentially there's no basis to this. And one of the examples might be that the person has no real intention of actually exercising their request. So it could be that someone makes a request and then 2 days later comes back and says, but I'll withdraw my request if you give me credit on my account or something like that. In which case, they're quite clearly not interested in actually exercising their right of access. They're using this as a leverage mechanism for some reason. And so in which case you could declare that the request is manifestly unfounded. And where a request is manifestly unfounded, you can refuse to respond at all. To comply with the request, you can just say, I'm not going to do that. It's manifestly unfounded, and these are the reasons for that. Similarly, you might find that a request may be one of any of these things on the screen, so frivolous or vexatious, unnecessary, repetitive, or otherwise excessive. So frivolous, there's just nothing, it's just a silly request. Vexatious, that they've actually said, I'm doing this because I'm going to gum up the works, I just want to make your life difficult. Unnecessarily repetitive, it's the 19th request you've had in from that person this week. And I'm not saying 19 is necessarily the barrier there, it's for you to decide whether that's appropriate or not, or otherwise excessive, so a request that's perhaps out of control or out of scope. So where any of the requests are any of these things, then you would need to decide what they mean for your organisation in relation to that request. Then you can either refuse to respond to the request, or you can charge a reasonable fee to do so. But the controller, so the organisation, bears the burden of proof when it comes to proving this. and therefore you should document your decision making. If somebody complains to this office because they feel their right of access has been denied on the basis of any of these, we will ask to see the documentation that meant that that was the case, that the decision was made, and we will assess whether that is appropriate for the request to have been knocked back, or whether actually something should have been done about it and it should have been complied with. So make sure you always document what's going on. And then there's one exception in the law, in section 16 of the law, the section just after subject access requests, that deals with disclosures of other people's data. So where to disclose information may mean disclosing somebody else's information, then you can, there's a section within the law that allows you to make a judgment as to whether it's appropriate to respond. And we've just had a question that just related to my last slide, just had a question come in asking, what if you're fairly certain that request is vexatious, but not 100% certain? If you, so our answer would be, if you can document your reasonings to why you believe it is vexatious, and what you mean by fairly certain, then that would be appropriate to document. You could then turn the request down, or say that you're going to implement a fee around that. And then if, as a complaint comes in, then we would seek the information to understand why it was felt that that request was vexatious. So you need to be able to put together a case that looks, fairly reasonable, that, yeah, that looked like it was heading towards vexatious, getting to vexatious. But it would very much depend in the circumstances, and some of it will depend on perhaps prior contact you've had with the individual. So it's unlikely one request, and that's the only thing you've ever had, is going to end up being vexatious. It may be something that's part of a pattern of behaviour that has been in the past that you could take into account. So hopefully that's provided some assistance around vexatious. Okay, so back to disclosure of another individual's personal data. As I say, sometimes personal data is so intrinsically wrapped up with somebody else's that it's going to be difficult to respond without providing that other person's information as well, or without at least alluding to the identity of the person whose data it is. So you can refuse to provide the personal data of the requester if it's felt reasonable to do so to protect the significant interests of the other individual. And section 16 of the law outlines some steps to go through and some things to take into consideration when you're thinking about whether it's appropriate to disclose or not, whether you're going to end up compromising somebody else's rights around their legislation. So one of the things to think about is whether there have been any steps taken to seek that person's consent. So have you asked the third party what their thoughts are around the disclosure? And has there been any express refusal by that person to allow that disclosure? And you need to think about whether the person that you're, the third party, is capable of providing consent in any event, and document your answers to those questions. The nature of the information, whether it be special category data or particularly sensitive data, may sway the decision one way or the other. So think about the nature of the information, document why it may either be important or to disclose or to not disclose that information because of that nature of that information, the nature of the data. Think about the interests of all the parties. So what does somebody have to gain through this subject access process? What might the third parties gain or lose as a result of this request and the disclosure of any information, and try to balance those and work out whose interests are more important. What we would say here is that if somebody is acting in a professional capacity, then it's unlikely that when somebody's acting in a professional capacity, and so it's their notes that they've made, their opinions about somebody that they've documented. So for example, it's a manager that has documented thoughts about an individual's performance. The rights of that manager are going to be slightly different than if it was an individual that had documented those things. So if you're acting in a professional capacity, you need to stand by that information and be aware that some of it will be disclosed in circumstances where perhaps it wouldn't have been before. So if I write a letter and express in a letter my thoughts about somebody, put in that letter how that made me in my capacity feel, then I need to stand by that, even though some of that personal data may be about me, and it wouldn't necessarily be appropriate for my information not to be disclosed, or for that to stop somebody else having that information. So it very much will depend on the role of the people involved and the expectations around that. Similarly, and it's more from the UK around freedom of information legislation, but thinking about personal data in the context of disclosure, if it's a junior member of staff's name, it may be less appropriate to have that attached to something than if it is a senior member of staff's name. So it's thinking about all the interests of the people involved and the roles that they perform. I don't know if that's done anything to clarify between company data and individual third-party data. We've got a question in there. I shall keep an eye on that one. So the context of the collection and the processing. So again, thinking about the manner in which the data was collected and what it is used for needs to be taken into consideration. So if it has been collected potentially as part of something that might become a criminal investigation, that it may be less appropriate to disclose that when you receive a request coming in. So think about that as you go through, and the relationship between parties. So again, very much linked to interests of all parties, about whether there's an imbalance of power in there, whether somebody's acting in a professional capacity. And then the reasonable expectations of the people involved. So what was somebody expecting when they provided that data or gave their opinion? And this would be taking into account things like duty of confidentiality. So if you owe a duty of confidentiality to somebody that would be compromised by providing that information as part of a subject access request, then it may be entirely reasonable to withhold that information from the response because it will be impacting on somebody else's duty of confidentiality. And that will often be have been explained at the beginning of the journey at the outset. So in counselling circumstances, for example. No, so yes, we've just had a question in about deleting email accounts for employees who've left the company. That will very much depend on the nature of information that's held in the email system. So I'll come back to that one towards the end of the session, but I'll bear in mind that's there. Okay, and then going on to when you're thinking about third-party information, to who the personal data is being disclosed and the circumstances of that disclosure, take that on board and assess that. Think about what safeguards there may be in place after information has been disclosed, and think about possible consequences. If somebody's going to be at risk of harm as a result of disclosing the information, even if it's then going to impinge and mean the individual who requested it can't have it, then it's entirely reasonable to not disclose that information. You would need to document your reasoning around this so that you can explain that reasoning if we get involved and are asked to explain what ask you to explain what happened. Likewise, it may be appropriate to take somebody through the information, but not appropriate to provide them with the ability to take a copy away. So if you want to have somebody come in and review the file, but not give them a copy to take away, then that's appropriate and a way of dealing with this situation as well. As I say, so this is conducting this reasonable test, documenting why you think it's reasonable not to disclose that information, and the answers to those questions that the law outlines. So then we get on to exceptions and exemptions, and this is where it starts to get hardcore, people. So buckle up. I'll go through, we've got a number of exemptions within the law. We've got guidance on our website that explains them all in more detail. And there are some exemptions that are not appropriate for use within or not applicable for use when dealing with a subject access request. But we'll go through these because there will be times when it is entirely appropriate and common sense not to provide information to somebody as part of a subject access request. And the law aims to capture those circumstances and provide the exemption you can rely on so you don't disclose that information. Key things to think about when looking at exemptions are you are not necessarily required to make use of an exemption if it's there. So if you decide that you want to be open and transparent and there's going to be no harm as a result of that as an approach, then you don't need to use the exemption, even if an exemption is there, and you could use it in your circumstances. and you should only apply the exemptions to the minimum extent necessary to achieve the ends. So if you can't disclose something to somebody because there's currently an ongoing court case, for example, and you don't want to provide that information because the police have told you that that shouldn't be provided, then you can withhold that specific information, but it may not be necessary to withhold absolutely everything. So using only the exemptions only to the minimum extent needed. The approach that you should take in line with this requirement to assist the facilitating of data subject access requests and data subject rights more generally should be to be open and transparent where possible. But as I say, there are circumstances where there are some exemptions that you can rely upon, and we'll go through those now. There is guidance on our website that can go alongside this. So the first set of exemptions within the law, and they're all found in Schedule 8 of the primary law, the law itself, are sort of general exceptions and exemptions. The first being confidential references. So if the controller, your organisation, has given a reference to a potential employer for a member of staff, and that member of staff or former member of staff then makes a subject access request, you can use this exemption to withhold that reference, so you don't need to provide that reference to the individual. But this exemption is only applicable to the controller that gave the reference. So the controller to whom the reference was given may be required to provide that reference because they are not able to make use of this exemption. So bear that in mind when you're approaching references. This would be one where if there were concerns about the nature of the reference given, and you were the organisation that received it, you'd look to section 16 and see whether it's reasonable to withhold that given the balance of reasonableness we just talked about. But in the main, the organisation that gave the reference can use this exemption, but the organisation that received it cannot. There are a couple of exemptions that relate specifically to judicial appointments, as I put my teeth in, and honours and crown appointments, where the information used to assess suitability for my OBE doesn't have to be provided to me if I make a subject access request. But I'm imagining that's not going to impact on many of us, but they're there for anyone out there who happens to be deciding on the New Year's honours or who's going to be the next crown appointment. There are another couple of exemptions within this section that relate to disclosure solely, so disclosure to relevant bodies to protect individuals from harm and disclosures required by law, and they're not applicable in a subject access context. But it's worth remembering they're there for other situations where you may need to, particularly thinking about protecting somebody from serious harm. There's an exemption around examination and marking data that says you can't have your entire script back when you've sat an exam with all the questions and all the comments and all your answers on it, but you can be given the marking information and comments that were made by somebody that marked your exam paper. So you can get your scores and you can get your comments, but you won't get your script back, so you can't then make use of it again or sell the answers, the optimum answers, to somebody doing the exam next year. If you are involved in any sort of examination or marking process, that is worth bearing in mind that the usual timescales do not apply. There's an exemption specifically in there that says if somebody makes a request for their examination script, exam marks and comments, that the usual 1 month doesn't apply, and you don't have to disclose generally until after the publication date. So nobody can use this as a way of getting their A-level results early and getting that place in at Cambridge University before everyone else has got their marks, because that would be inappropriate. So that's in there to say that the usual timescales don't apply. And one exemption, the last exemption in this section, so part 1 of Schedule 8, relates to privileged information, so information that is deemed legally, professionally privileged, and privilege is defined specifically within the police powers and criminal evidence legislation locally. So where correspondence between an organisation and their legal advisors contains personal data and is privileged, there's no requirement to provide that information because it would waive privilege. The next set of exemptions are all based around prejudice. So these aren't ones that exist solely because the information falls into that category. You need to do something known as a prejudice test to work out whether disclosure is going to prejudice the purpose for which the data is processed, and therefore if it's appropriate to withhold that information. The first one in part 2 of the law relates to armed forces, and I don't think we have anybody here from the RAF or anything like that, but information you'll be pleased to know from a more general security point of view and feeling safe, any personal data that's going to impact on sort of combat readiness, that sort of thing, won't get disclosed. So we're not going to compromise the appropriate operation of our armed services by requiring disclosure, so that's good to know. An exemption that may be used though by organisations is one called management forecasting or planning. So if you are looking at doing a staff reshuffle, if there's perhaps going to be redundancies coming up, while you're having those discussions, while you're having those thoughts, while you've got your flowcharts out trying to design your organogram or whatever you're up to, if somebody makes a subject access request, and providing information around that process will prejudice that, so will potentially upset other members of staff, will mean that people start leaving, that you lose control over the process, then you can seek to withhold information or redact information from the response using that exemption. This one, you need to be clear that it is the information that only relates to management forecasting and planning. So generally giving somebody a copy of their HR file is fine, and it's unlikely this would apply to it, but the secret file you've got that you're dealing with the restructuring in, it may be less appropriate to disclose that, and you can rely on this exemption. This exemption will likely fall away over a period of time. So once your plans have become known, once you've disclosed what's going on to the rest of the organisation, the redundancy processes in place, that sort of thing, and everyone knows about that, if you got a request at that point, you wouldn't be able to make use of that exemption, and you'd need to disclose the information. Financial services is the next exemption. So this relates to particularly the pricing of certain like stocks and shares and that sort of thing. So it's very specifically related to certain financial services organisations, and most of us won't go anywhere near this and won't have a clue what any of that's all about. But if it's going to undermine the price of stocks and shares by disclosing something before due time, before it's appropriate to do so, you know, a bit of insider trading, that sort of thing, then you can make use of this exemption to not disclose that information. Again, you need to make sure that there's you can demonstrate prejudice, so that it's going to prejudice something to make the disclosure, so that you can make use of this exemption. And this one will again fall away. So when the price of stocks and shares goes live and everyone knows about it, then this no longer can be made use of. And so if someone made a request at that point, you'd need to disclose. The next exemption relates to negotiations. So if you're negotiating maybe a cost of a claim as an insurance company, or negotiating with a member of staff around them leaving the organisation, you're not required, if you receive a subject access request while those negotiations are ongoing, to show your hand, so to speak, as to what your upper and lower limits might be as part of that negotiation. And so you could withhold the fact that you would pay them 30 grand if they left, if they're quite happy to go for 15, which doesn't sound terribly good when I say it out loud, but it's an option that's there. So this is an exemption that's there. But again, it's only, you have to be able to demonstrate prejudice, and it's going to be time-based. So when it's no longer, when the prejudice no longer exists, then you would need to make the disclosure. There is an exemption around self-incrimination. So if you're going to incriminate the organisation into have been doing something wrong, then there's no requirement to do so, except around data protection. So you can't use the exemption to get out of the fact that you didn't do something data protection related appropriately. So I would suggest you look carefully at the wording around that one before you make use of that. And you need to, again, make a prejudice assessment around that one. There's one specifically there about judicial independence and judicial proceedings, but I don't think we've got anybody in from any of those areas. So just to note that's there, but there's not necessary here. One that's particularly used a lot will be tax and crime exemptions. So where to disclose some information will prejudice law enforcement or prejudice the collection of tax, then that information can be withheld. This will be the one that financial services organisations out there that have money laundering reporting requirements will potentially make use of. If you've made a suspicious activity report, the acronym of which is SAR, like subject access request, so helpful there. But if you've made a suspicious activity report to financial crime unit up at Ozone Hall, whatever, then and someone makes a subject access request, you're not required to provide that. You can make use of the exemption to not provide that if it would prejudice the case in order to provide, if that was provided. There's also another bit in the next section about that probably falls into the tipping off thing as well. So yeah, you're not required to let people know that they're being investigated if it would prejudice them to do so. Then there's an exemption relating to international obligations. So where there's an international obligation and that would be prejudicial to disclose, you can withhold data. Probably, again, not one that we use a lot. There's one in relation to protective functions, and protective functions would be things like protecting individuals against financial misconduct or issues around health and safety or the reputation or standing of the bailiwick. So if to disclose information would impinge on the workings of that, then you can withhold that personal data. And there's one for regulatory purposes that's similar in some respects to the tax and crime. So where an administrative offence is being investigated and to disclose at one point will prejudice that, then you can make use of that exemption. But where you're looking at prejudice, often the prejudice will change over time. And so the decision you made last year when somebody made their subject access request may be different if they made a request this year, because time's moved on and situation may have changed. And you should only withhold the minimum necessary to get rid of that prejudice, to deal with that prejudice. So if you have an entire HR file and there's 2 bits of paper in there that relate to the fact that you think the person's been taking money from the organisation and you've reported them to the police, you can withhold those around tax and crime exemption, but you would give the rest of the information because it's not going to impinge on the ability for the police to do their investigation and to have that control over when the individual finds out what's going on. So just to be aware about those 2 things with these. There are other exemptions. One relates to where legislation itself specifically prohibits or restricts the disclosure. So if there's a piece of law that says don't give this to that person involved, data protection is not going to make you provide that information. You can rely on this exemption in order not to disclose that information. And again, this one is one probably used a lot in relation to financial reporting. There might be some suspicious activity going on and where you shouldn't tip somebody off to the behaviour that they've exhibited that is of suspicion. In addition, it's specifically listed under this exemption as adoption legislation, but there will be other bits of legislation out there. This is sort of catch-all exemption to wrap up any bit of law that says do not disclose this to the individual directly. There's a specific exemption in relation to trusts that aligns with the section in the trust law about providing information to beneficiaries and letters of wishes from settlors and that sort of thing. So if you're dealing with trusts, it may be worth having a look at that exemption in advance so you understand how it works before you get a subject access request coming in. There's an exemption around court-directed non-disclosure. So if a court has specifically said some information shouldn't be disclosed, then you should agree with the court and do what the court's told you, but it has to be directed by the court itself, and it has to be the specific information that the court has said should not be disclosed. So it's not necessarily all the information you hold about that individual if the court has only directed that one document is withheld. So just be careful about how you apply that one. If it's going to cause serious harm to provide information to an individual or to any other individuals, serious harm to any other individuals, then you can withhold the personal data. So an example might be if it would be detrimental to the individual's mental health and well-being, to provide them with a full copy of their medical record, in which it might include some information of particular distress, then you can, if you're a health provider, make the judgment not to provide that information because it would cause them serious harm. Or if you are a non-healthcare controller, seek some advice from individual who from a GP or a medical professional about the risk of harm. Or if to disclose information, for example, to tell somebody that someone else has been, I'm thinking, yes, to disclose anything around sort of domestic violence, that sort of thing, then you can withhold that information so it doesn't put anybody at risk of harm. And there's another one here around requests that may be made by other people. So there's no specific age in the data protection legislation that says when an individual can make their own request. It will often depend on the nature of the information, but often around 12 or 13, when somebody's about 12 or 13 years old, they could themselves be responsible for making their own requests, and their wishes should be taken into account when it comes to disclosing that to perhaps parents, that sort of thing. But there will be some circumstances where for younger people, or for perhaps people who are vulnerable and have court-appointed guardians, that whilst the subject access request can be made by that person on behalf of the data subject, if there's any information in there that is going to be detrimental to the data subject to provide, such as if they've made disclosures about abuse in the past or that sort of thing, then that can be withheld because it's not appropriate to provide that to the person with either parental responsibility or court appointed. This again is likely to be something in certain areas. Healthcare, for example, might be an area where this is needs to be considered more than elsewhere. Some legal processes or anything relating to child protection is worth bearing in mind. They're there so you don't disclose something that puts someone at risk. I'm going to have some water now because I've talked solidly for an hour. So there we go, bear with me. Okay, so the last section of exemptions relates to those exemptions that are in the public interest. There's one in relation to processing for journalistic, art, literature and academic purposes. So around freedom of speech, and then the speech that's in the public interest, where it might be in the public interest to do something, this exemption applies. It could be used in the case of subject access, but more often than not, it will be used in other circumstances. So to process data that the rest of us, other organisations, wouldn't be able to do, but it's appropriate for journalists to do so in order to cast light on some activities that are in the public interest. And likewise, in relation to public security, so national security type issues, it may be appropriate to withhold information that otherwise would be disclosed in other circumstances where there's a public security angle. And again, that's probably quite specific, so not necessarily for every organisation. So those are all the exemptions we've gone through, thankfully. So I've got another poll for you now. So the third poll is, can you withhold people's information from them indefinitely? So Tim, can you launch the poll, please? The answers being no, never, yes, always, or it depends. So what do you think about withholding somebody's information from them indefinitely? Okay. It looks to be fairly concrete answers there. So if we want to stop that one now, thank you, thanks, and share the results. So here we've got 95% of people have said it depends on which exemption or exception you're trying to use to withhold the data, and one person has said no, never. I like the spirit of the person that said no, never, because we shouldn't be just thinking about ways of stopping people having access to their data. And most exemptions will not necessarily apply all the time. But if we have a look at the answer here, unfortunately, it's one of those where it does depend. And I know people would like a yes or no answer because that's easier to deal with, but it will depend on which exemption you're using and the nature of the information. There are a couple, such as one relating to where legislation says you shouldn't disclose something where it could well be an indefinite thing, and it doesn't matter how long has passed, that information still can't be disclosed because there's a legal obligation to withhold it. But in most cases, it won't be indefinite, and you need to just consider it. So yeah, as I said earlier, just because somebody made a request last year and certain exemptions applied doesn't mean if they make the same request this year that the same exemptions will apply. Things will have moved on, situations will be different. It might then be appropriate to disclose it where it wasn't before. And you should always assess disclosures, even if you have done one previously and an exemption applied, because these things will change. It's not necessarily appropriate just to assume it's going to apply as a blanket thing forever. So then if we just do a quick recap on how to respond to a subject access request, or how to get ready to respond. So back to this idea of having this documented process and knowing the information that you've got at your finger and knowing where it is so you can get hold of it when you need to, and making sure you understand the right people in the organisation to get involved. Share the blame and burden, and make sure you get the right answers from the right people. This idea of minimizing your data, so go and have a good clear out. Not saying get rid of everything, because there is a requirement to retain information in some cases, but if your retention schedule says you should have held it for 6 years, then at 6 years get rid. And that's quite cathartic. That's a between Christmas and New Year type task, to get the shredder out and start getting rid of information that you should be getting rid of in accordance with your retention process. Test the process, try and make sure that it withstands whatever might be thrown at it, that you understand what's going on, that you recognise the requests and they get pushed through the organisation quickly. And as I say, so that you're thinking about this link between customer service and finding out how best to service the individual. And make sure you document any decision making, because the burden of proof, as I say, is on you as the organisation rather than on the individual. And you will need to prove why you've made the decisions you made. And we will ask for that, and we will take that on board. And that's why it's difficult for me to say here and now that exemption definitely applies and that one doesn't, because it's all situational and things may change over time. But if you've documented it, if you've got a really good reason why it worked for you at that time, then we will take that into consideration. And it's part of demonstrating your accountability that you're taking things seriously. And if you've made decisions in good faith, then that will be taken into account if there are any complaints that have been made. So don't be scared to document it and have that discussion with us if it needs to happen. And then test the process again. So this one here, question here that we sometimes get asked. So an employee is leaving your organisation. Can you contract them to never make a subject access request once they've left your employment? Can we launch this poll then, please, Tim? So somebody's leaving. Can you have a contract with them that says, go away, never make a subject access request? Is that a no, never, a yes, always, or it depends on the circumstances? Oh, that line's going upwards and back and forwards. Okay, just a couple more seconds. And then if we can close that one, Tim, please. Okay, and sharing the results, thank you. So 24% of you said it depends on the circumstances, and 76% went for no, never. And thankfully, nobody went for yes, always, which if I take anything away from today, it's the joy at knowing nobody went yes, always. The answer that we would be looking for is no, never. So whilst as part of a some sort of compromise agreement, it might be agreed that by virtue of whatever the agreement says and whatever the settlement is, that you won't go on to an employment tribunal process, because the document, the compromise agreement, will represent potentially an early settlement of any employment tribunal process. It's not appropriate to ask people to forego their rights. This is a right as provided under legislation. It's one of a number within data protection law, but one of a number of rights across the board when it comes to legislation. And just as nobody should be asked to get rid of or sign away their right to a fair trial, then no one should be asked to sign away their rights under the data protection law. So it should be a no, never for that one there. And if we go on to poll 5, if we can launch the last poll, then what do you think is the single best thing your organisation can do to prepare itself to deal with the subject access request? So we have here, for this one, we have a documented process, know your data, involve the right people, not just the DPO, minimise your data, test the process, understand the link to customer service, or document decision making. So what do you think for you would be the process for you? I'll give just a little longer for this one because it's a lot of stuff to have to read. Okay, if we can shut that poll down now, please, Tim. Thank you. So there are the results. So the one that came out at the top, 37% said have a documented process, 21% know your data and test the process, shared there. 16% is document your decision making, and 5% have gone with minimize your data. Now this one, there probably isn't a right or a wrong answer, not that one that I can tell you anyway, because it will very much depend on your organisation, what the processing looks like now, what you already have in place, so where you are along the process of dealing with subject access requests, what lessons you might have learned as part of being involved in processes, and then things that you may have picked up from today. But making sure you are aware this is something that could come in, that you want to get ahead of the game and not just wait till your first request comes in, and have an idea about what's going on in your organisation. All things that you need to think about when dealing with the subject access request. So we've got a bit of time now for questions, and I've got a question here from someone asking about email accounts, and is it best to delete email accounts from employees who have left the company, or is there an optimum length of time to keep such records? Now this one can be an interesting one because it much depends on how you view email and whether you think email is something different to the other systems you have in the organisation. If you are transferring data from your email and storing it elsewhere, then it may be appropriate to delete the email accounts of individuals when they leave. You may well have let people have access to use the email for their own personal use. And so you might end up coming across personal information in there that you wouldn't want to see while you were searching for something else. And it may be actually that it's more appropriate that the HR emails are stored in the HR filing system, electronic or otherwise, and that the emails between you and customers are stored in the customer relationship management system or with other customer records, and the email isn't seen as a distinct set of data, but merely a means of processing it and getting information to and from places. And so it would depend on how you deal with your email. Have you got strict rules in place that say everybody must store that information in the right place? Is the only place it's ever stored in email, in which case it might be that you have to keep email accounts for longer. Is your system clever and fancy, and does it automatically send the data to the right place when you get an email in because it's all been tagged and that sort of thing? Then you might be all right to delete the email accounts as soon as somebody leaves or after a shorter period of time than other sets of systems. So it would very much depend on how you use the systems. This is one of those occasions, I'm afraid, and they come up a lot in data protection where there isn't a yes or a no answer. It depends on how you use the system, but you need to take into account, are you going to be capturing things you shouldn't by keeping the emails longer? And is there a better way to store it? Okay, so another question, if we were to maintain details of which staff have a personal relationship with other staff in order to manage conflict, would this be regarded as sensitive personal data? Sensitive personal data as a concept doesn't exist under the new legislation because it's a special category, but more sensitive than others. It may well be. The information may disclose, if you're keeping information about who's partners with who, then that may well be information relating to somebody's sexual life, perhaps, and so would need to be viewed appropriately. So there could be circumstances where it might be more sensitive information and more, and you would want to be more careful with it, perhaps, that the so the right people, such as managers, know not to put those two people on the same project, or to be aware of the risks that come with the relationship they may have, but it may not necessarily need to be something that everybody has access to, particularly if it's something that the individuals themselves are more careful about. So if they've reported it in the appropriate fashion according to your staff handbook and your policies and procedures, you may wish to treat it as somewhat sensitive, but there wouldn't be anything necessarily that would stop you just having that information, and being aware that if somebody were to make a subject access request, that you would disclose the fact that you are aware of that relationship, because it will be impacting on decisions perhaps about how you deploy your staff if there are conflicts of interest. So I don't know if that helps. Any other questions? This is this really bizarre bit where I might just be sitting here talking to myself for the last hour and a half. I miss people's faces. Okay, so if there are no further questions, oh no, one more there. Should you redact staff, current and previously employed email addresses when providing email correspondence to a customer? That would very much depend on, I think, on your processes around whether somebody deals with one specific person or whether there's generic emails around. From a practical point of view, you may wish to redact email addresses of previously employed staff, because you don't want them to send it to them, but have some other way to show that that individual may have had access to that email. Business email addresses are one of those interesting things because they can be personal data by virtue of the fact they're made up of combinations of people's names. And so you would want to be careful about disclosing that. Where to do so would be inappropriate, but if it's someone that's got an ongoing relationship or has had a relationship with that member of staff in the past, then there's less risk there. So I think it's more on a risk basis around harm to either of the parties involved when you're coming to decide whether to redact or not. If you try to funnel everything through a generic account, then you might want to look at dealing with that one. Somebody just came in and waved at me, which is disconcerting. Then if there was serious psychiatric information, would there be the chance that the information is never disclosed? Yes, there could be. If there's serious information with serious implications around psychiatric or mental health well-being, then there could potentially be the chance that it would never be disclosed. But that's probably not a decision that should be made once and then held in place forever. It's something that should be reviewed if you get any future requests come in. And I know from discussions I've had with healthcare practitioners that sometimes this is where they might not provide that information to the individual to have a copy of at home, to perhaps mull over in an unhelpful way, or that they don't see it cold, that actually if there was information that they might not get a copy of to take away, that perhaps the healthcare professional would sit down and discuss that with the individual themselves so that they know what's going on, they're aware of what's been recorded about them, and they're not being kept in the dark about something that they could know about, but that is dealt with in a more sensitive way, more compassionate way, and so that the person understands the data, because it's seeing something in black and white is quite scary, and actually it might be better to talk it through with somebody before you give them a copy, or never give them a copy that they can take away, but just have that discussion with them, and be open and transparent and support them through that journey. I hope that's helped. Anything else? Trying to see, it would be really handy if this was like those chat apps that give you the 3 three dots to say someone else is typing, and then I'd know not to carry on. So I'll carry on and come back if we have any more questions pop up. So just to think about as we head towards finishing off. Oh, look, there's more questions on the other sheet. We've got questions and others, so I'll come back to those questions. Actually, we'll do those questions now. Retention periods. If an organisation has email Mimecast, which holds data for 50 years, but the organisation's retention period is 6 years, should that data be deleted? Yes, if your retention period is only 6 years, you shouldn't hold anything for longer than that. If technically it's difficult to get to that information because it's all backup tapes and things like that, then you would need to have a policy in place that says if any information from that backup tape was ever restored, that you don't use the information that should have been disclosed, or has already been gotten rid of. So you might get it back for one piece of information, but your restore might take a lot of data back and you might have more than you needed. Then get rid of anything extra again. And how detailed should a response be to a SAR? If we hold a copy of someone's passport, is it sufficient to say we have a copy of your passport? If we hold this date of birth, nationality, etc., or do we need to give them back a copy of the passport? You don't necessarily need to give them every single document you have, but you need to give them the personal data within that information. So explain what you've got and provide the personal data. If you've only got their address and you've got it on 97 generic letters about terms and conditions and things, then potentially you don't need to provide each of those 97 letters. That just saying you've got their address will do, but it will very much depend on the context of the information. And people may be expecting to get copies of data back rather than summaries or outlines of personal data. And so there might be something you need to do around expectation management when you provide the data back, but the law doesn't necessarily require you to provide each document separately, but the personal data within. And where it says person may be mentioned many times in email chains, do you have to print entire email chains? Again, it will depend on the nature of the information within and whether that information is somewhere else. So if the email chain has been summarized into a general report that's provided, then it may be that you don't need to provide the entire email chain. But if there's personal data within the email chain that they haven't had, you will need to get that personal data out or copy, provide that email or the email chain itself. So I don't know if that's helpful. So yes, I think that's all the questions now, unless somebody's found another place to put questions, because I found two. If someone's found a third, well done. I've not got it. So we'll see. If you have any questions after this event, then by all means email our inquiries email address and we can get back to you anyway, because as is often the way with these things, you'll go off and start thinking about something and 94 questions will come to your mind and they'll be specific to you rather than generic. So get in touch. So moving on to our Project Bijou. So in May 2021, we launched Project Bijou, which is a social initiative aimed at engaging people in the protection of their own and others' data through culture and stories, on the basis that people love a good story. You gather at the pub and tell stories. We've been gathering around campfires for hundreds and hundreds of years, telling stories. And that's a good way to pass on knowledge. It's worked for our ancestors and got us where we are today, so let's carry on doing that. And the idea is to take data protection beyond just sections of law and legal definitions, but emphasize the human side of data protection and the implications that there can be from good data processing and what happens when things go wrong, the data harms. So we're thinking about culture change and using, as I say, these stories to demonstrate harms and build engagement. And the essence of Bijou is to seek to change behaviour, shift culture and reduce harms through effective sharing of information and best practice and worst practice, because sometimes we learn the best from the stuff that's all gone wrong. And I have a dream, but it's neither Martin Luther King's nor ABBA's, about a day when we cease to do data protection, but we just have data protection as something that exists within being a good business, being a good organisation. So Project Bijou seeks to engage with that concept. We've got lots of resources on our website, lots of people telling us stories about how they use personal data, the benefits they get from it, where it's gone wrong and how they've learnt. and been on their own data protection journey. So by all means, go to our page, Bijou page, and have a look at that and get involved. As I said, we're also working to provide you with as much support and information to you as our regulated community and the citizens around the data protection legislation. So we run our fortnightly drop-ins for questions. So by all means, come along to one of our drop-in sessions. You'll get at least half an hour with a member of staff to talk through your specific issues. You can also email us or sign up to our newsletter and look out for future events that we're running or resources that we're putting out online. So I would encourage you to have a bit of a browse of our website and have a look and see if there's any content there that takes your fancy. We're also on LinkedIn, so you can follow us there. We post quite a few updates about Bailiwick data protection, but also looking at global issues. So have a look at that. And we're thinking, as I say, taking it to the essence of data protection as we see it at the ODPA is this idea of the human at the heart. So this is the key point I want you to take home, bearing in mind some of you might be sitting in your home. As I'm conscious I've bombarded you with an awful lot of information today, and this is only just a start. If I didn't have a clock running, I'd carry on all afternoon. But if you remember one thing from this session, it's to focus on the human being that is at the heart of the subject access request. This is subject access, and all the data subject rights are rights that they have. They have a right to know and understand what you're doing with the data that you have about them. It's them who are harmed if things go wrong. It's them who are confused and baffled if they don't understand what's going on with their data. So make it easy for them. Try not to go on the defensive. Look to engage with people positively around this process. And build bridges, even though I recognise sometimes the relationship can be tricky. That way the whole process benefits everyone. So one last question: how long after leaving a business could an employee request a SAR from you? Is this potentially forever too? It is potentially forever too. But if you've gotten rid of the information after 6 years, for example, because your retention policy said that that's how long you can hold it for after the individual has left your employment, the answer could be no, we no longer process your personal data, and that's you're dealt with your subject access requests. You do not have to keep personal data just to comply with a subject access request if you ever get one in. If the retention period is such that it should have gone, then it goes, and you're actually on a much more sticky wicket if 10 years after they've left the employment and they put in a request and you go, oh yes, I've got all of it here, when it actually should have gone 4 years previously. So yes, hopefully that answers that question. Thank you all very much for your time. I know this is a slightly bizarre way of doing these things, and I've not gotten used to them yet, even though we've been doing sitting on Zoom and Teams for the last 18 months. So thank you all for bearing with me. And if you've got any further questions or you want to come in for a drop-in, then just get in touch. Thank you very much.